Since you've been on the court, one of the most important decisions that's come down was the Dobbs decision.
Hmm.
And that case was famous not only because it reversed an existing precedent, but it was leaked in
Right.
advance, which I don't think there had been a leak like that before.
Mm-mm.
So the Supreme Court tried to find out where the leaker was, and typically in Washington, you never can find out who the leaker was. But has the Supreme Court changed its procedures in any way to kind of make it less possible that somebody could leak something?
Yeah, as you say, there had never been a leak like that before. No opinion draft had been leaked as that was. And we did do a review and have tried to take steps to try to ensure that that wouldn't happen again.
So today, when you are looking at overturning a precedent, is that a very difficult decision for a court when you're overturning a precedent like the case that overturned Roe v. Wade? Was that take more time for the justice to really go through those kind of things because you realize you're overturning a precedent, or they're treated the way almost any case is, you just look at the votes and that's what it is?
Well, I wouldn't say that you just look at the votes in any case because you're considering all of the arguments that lie behind the votes. In any case where you're considering whether to overturn precedent, there's a double layer to it. You're first considering what is the right answer to the legal question, which is, was that precedent, did that precedent get it wrong? But then that doesn't decide the question of whether you should overrule it. There's a whole second step at which you consider, okay, even if it was wrong, should it be overruled?
In the early days of the court, opinions were written, and that was the opinion of the court. And then later in the court's history, they began writing dissents. That wasn't initially, I think, part of the court's practice. Now the dissents often are, I would say, a little more personal. They kind of say, well, I can't agree with this. This is a really bad decision. The majority, you find the tone in the dissents is a little more personal than it maybe used to be, or nobody thinks that?
Well, there were dissents from the beginning. There were
were.
dissents in the beginning, yes. So in Chisholm versus Georgia, there was a dissent. So there were always separate opinions. It is certainly true that the style of separate opinions or their number changes and it ebbs and flows over time. But I think one of the important things about dissents, you were mentioning it when we started our conversation, that in the law, arguments on paper are about ideas. And I think that that is one thing about the court, that the court has been successful thus far in maintaining, that these are legal arguments, but they're not personal attacks.